Members, good morning. It's already our appointed time, or it's already past our scheduled time, and with formal quorum, may I call the meeting to order. Please invite the administration to join us. Present at this meeting, we have Mr. Asin Yu, PAS for Financial Services and Treasury, Ms. Ada Jung, Registrar of Companies, Ms. Phyllis McKenna, Deputy Principal Solicitor from the Companies Registry, and Mr. Sonny Chen, Senior Assistant Law Draftsman, Mr. Henry Chen, Government Counsel, Mrs. Christine Francis Sid, Senior Solicitor from Companies Registry, Ms. Margaret Chen, Solicitor from Companies Registry, Ms. Phyllis Poon, Senior Government Counsel from Department of Justice, and Ms. Cindy Churk, Government Counsel from DFJ. There are 9 members in their team. Good morning. We continue with our clause-by-clause scrutiny from our last meeting on the 21st. Before we do so, we've completed the company's words and expressions in company names in order, and company's accounting standards prescribed body regulation. We completed the clause-by-clause scrutiny of these 2 regulations in the last meeting. And we still have 3 regulations to complete. And at the last meeting, we also asked the administration to provide responses to some questions. And we've got paper CB 1610/1213(02) from the administration. So, Mr. Yu, are you going to walk us through the paper, please? Thank you, Chairman. Members, good morning. On the 21st, we met for the first time, and members raised some concerns in relation to the company's disclosure of company name and liability, status regulation, and also company's directors report regulation. And we have provided a supplementary paper to address members' concerns. Paras 2 through 5 are mainly on the requirement of regulation for companies to display their registered names at registered office. Well, the UK and Australia have similar requirements, and we're closer to the Australian requirement. We have a definition for business venue, and if the venue is open to the public, then the name has to be displayed, and this is different from the existing. So in the past, all business venues have to have the name displayed. We've introduced a change. The name is only required to be displayed at a business venue open to the public. And members asked about what is meant by open to the public, and in paragraph 3 we tried to explain that the meaning of open to the public is to be given its ordinary meaning. If it's just open to company employees, of course, this is not open to the public. And if the venue is not open to the public, then the name doesn't have to be displayed. Now, if a guest or the visit is only made by solicited guests, then again, the requirement doesn't apply. Paragraph 4, a member asked about the meaning of the term manager, because In Section 2, there is already the definition of manager, and a receiver or manager of the property is specifically excluded. So, again, in the new seal is just the same, and in the new seal, we frequently use the phrase managerial or manager of receiver manager of the property. So we believe that the meaning is clear when the provision is read in context. Paragraph 5 is about enforcement position concerning the display of registered names. In the past 3 years, the company registry has received 16 complaints and issued 24 summonses where fines were imposed. Please refer to paragraph 5 for details. Paragraph 6 to paragraph 9 is about disclosure of registered name in communication documents and transaction instruments. Paragraph 6 is about the definition of communication documents and transaction instruments. We follow the definition in the current CO, and we'll talk about formal documents. So, as said in paragraph 8, for casual communications between company officers and outsiders, they're not covered. For instance, just an SMS, it will not be subject to this regulation. And in a formal document, the company's name has to be shown. However, this requirement would not affect the validity or otherwise of the document. The intention is to ensure that the other party knows that it is dealing with this company. Paragraph 9. A member noted an abbreviation, COY. The purpose of including it in the regulation is that a company can use COY as an abbreviation for company. This might not be commonly seen, but there may be still companies using this abbreviation, COY dot. This is something in the existing CO, and we have no intention to change it. Otherwise, existing companies might be affected. And we don't see any major problem in including COY. Paragraphs 10 through 14 is about disclosure of information relating to debentures. The existing CO provides that a director's report shall contain information about arranging subsisting at the end of in time of the financial year. However, this requirement on debenture is no longer included, and we explained the rationale behind this requirement. Back then, the issue of debentures was only one of the means of financing for a company, and I believe it was different from the nature of shares. And in the UK, there is no such requirement for disclosure in the director's report, so we decided not to require that in company's report, but we are willing to consult members on this. Paragraph 13. Some members asked about the situation of listed companies. In listing rules, all listed companies, whether they are incorporated in Hong Kong, are required under Section 129D of the existing CO to disclose certain information, and that is information related to a company's report. Under the existing CO, a listed company has to disclose all information where a company is required to disclose in Hong Kong, and all connected transactions are also required to be disclosed. Whether it is a connected transaction, it will depend on the listing rules. Paragraph 14. That's the disclosure of debentures. We don't propose that this disclosure be made in director's report. However, there are ways and means where members of companies can know about the liability of the company. This include the financial reports. And under Section 316 of the new CO, a company must, within 1 month after an allotment of debentures, provide a return to a registrar of companies for registration. It also has to maintain a register to include the amount allotted, the particulars of each allottee, and the date of allotment, and other issues. So these are requirements under the new CO. I pause here. All right. The administration has provided a supplementary paper in response to queries raised at the last meeting. Do we have any follow-up questions for the administration, please? If members are happy, then we continue with our cross scrutiny. Okay, thank you. We will continue with the remaining 3 regulations. Please, administration. Companies Directors Report Regulation. Yes. Well, because of the follow-up issues, we skip the company's disclosure of company name and liability status regulation. With your permission, Chairman, perhaps we can tackle that regulation now. Yes, please. Company's disclosure of company nature and liability status regulation. There are 7 sections. The first is the commencement. Just like other regulations, we propose that this will have the same commencement date as the empowering ordinance, that is the Companies Ordinance.
2 is the interpretation, which refers to the definition of several terms. For example, communication document. I think this is actually the same as it is as in the case of the existing Companies Ordinance, except that in 2(2) we say that such communication documents and transaction instrument, whether or not it's in the form of hard copy or in electronic form or any other form, the same regulations apply. So we're just clarifying this requirement here. There is a new definition, which is the business venue. As we already explained just now, we now propose a change. That is, for the business venue, it is restricted to premises which are open to the public, in which case the name of the company will have to be displayed. So under interpretation, we have provided a definition, and we also, if the business venue is not open to the public, then it will not be governed by the requirements under the provision. Clause 3. Display a registered name at registered offices. We are reiterating the requirements under the existing CO. That is, company must display its registered name at this registered office or business venue. Subsection 2. The registered name must be so positioned that it may be easily seen by any visitor to the office or the business venue. It would have to be painted or displayed. So 3(2) said the registered name must be so positioned that it may be easily seen by any visitor. So, for example, if the reception office is behind the glass window, then the name would be displayed there so that it could be easily seen by the visitor. For subsection 3, we understand that some companies could provide company secretarial service for other companies, and its office could be the office of many companies, displaying the names of many different companies. So we now have introduced a new provision, that is, we would allow for electronic display. Where more than 6 companies are using the office, then the display of the names of such companies could be done in an electronic form. And the requirements regarding the registered name is also should also display for at least 15 continuous seconds, at least once in every 4 minutes. And this provision is also found in the UK provisions. Subsection 4 and 5 provide for the exemptions. For example, if the company had never had any accounting transactions, then subsections 1, 2, and 3 will not apply. For subsection 5, in the case of a liquidation, the liquidator, the receiver, may enter the premises of the company, and the venue in this case will become the business venue of the liquidator. And requiring them to display the name of the company in this case would be inconvenient to the liquidators. Under such exceptional circumstances, we will waive such a requirement. Section 4, registered name to appear in communication documents. As I said earlier, a company must state its registered name in any communication document or transaction instrument, and that it should be done in a legible manner. The change to the existing ordinance is that we will require the company to display its name on its website. With websites getting more and more popular, we think it is necessary that the company should display this name on its website. Okay, go on. Section 5 is about a more exceptional circumstance. Regarding the requirement to display the name of the company, for the majority of companies, the display of the name of the company would already include the word limited liability. So, in disclosing the name of the company, if the limited liability status of the company is also displayed, but in Section 103 of the ordinance, we provide that for certain companies, for example, charitable organizations, they will be exempted to have the name limited liability. And in this case, or in displaying the name of the company, it doesn't have to show the status of limited liability of such a company. However, it has to also inform the public that the company is incorporated with limited liability. And this is a similar requirement under the existing CO. For companies in Hong Kong, they may only register its name in either Chinese or English. We have the requirement that if the company's name is only registered in one language, if it is in the form of the translation of the name, for example, the company's name is registered in English and it wants to have a Chinese translation, then we would require that the Chinese translation of the company name would also need to be displayed, so that it will not do away with the term limited liability. The existing CO its requirement for the display of the name of the company in Chinese and English. But if the company has obtained a permit, then it will not need to comply with this requirement. Under the CO, we do not think that we need to retain this permit, because all companies would comply with this requirement. For the permits which have already been issued, they will continue to be in force. Please go on. Section 6 basically are the existing provisions. That is the displaying of the name of the company, in which case abbreviations may be used. For example, CO or COY in lieu of the word company, or LTD in lieu of limited, where abbreviations are used, or where capital or small letters are used, or where there gaps are found in between letters. Such change in syntax would not mean that the company has failed to comply with the requirements regarding the display of the company's name. All this is in the existing CO. Mr. Sin Chung Kai. I'd like to go back to section 5 bracket 5. I don't quite understand. What do you mean approved in writing in a manner in which the name in Chinese characters was to be used? Mr. Sin, are you referring to section 5 bracket 5 A? Well, this is because the requirement is here is that the company has only registered its name in English, but it also wants the Chinese translation for that name. And it also want to do away with limited liability for that translation in Chinese. And if he wishes to do that, he would need to apply for a license from the registrar. Under this license, the registrar will direct that there are certain regulations to comply with, and if it wishes to do away with the term limited liability. We're proposing to keep this license. Section 5 also stipulated that the permit will only be valid if the company complies with the requirements laid down by the registrar. Okay? Mr. Sin, I still don't quite understand. No further questions? Please move on. Section 7, in respect of the offences. Basically, they are in line with the provisions under the existing CO. As we've said at the first meeting, the major amendment here is that we've made some offences in respect, made some amendments in respect of offences. For example, for failure to display the name of the company in its documents, only the company will be held liable. Under the new CO, both the company and the responsible person will need to be held liable. So and this is actually in line with the rest of the new of the provisions in the new CO. The daily fine in respect of any breach that has been scrapped. So in case you have a breach, there won't be a daily fine. There will only be a one-off level 3 fine. As for the other offences, we now have this new requirement that the company would need to display the name of its name on its website. So the relevant offences would include a failure to do so. If the company failed to display its name on its website, then it would be an offence, and this is under 7 bracket 2B. Mr. Sin, I'm sorry I've not been able to catch up. I'd like to go back to the part about any website. Could you speak up a little bit, Mr. Sin? I've not been able to follow. Section 4, 4C, the company's name must appear on any website. You may have a company selling different products. For each product, there could be a dedicated website. Does it mean that the name of the company would also need to be displayed on those designated websites? And I'm referring to 4C here. Basically, that's correct. If the company operates through many websites to sell its products, then on each of the websites, the name of the company will need to be displayed. Mr. Leung? Chairman, I'd like to go back to Clause 3, Subsection 4. At the last meeting, the Bureau already gave us an explanation regarding the term accounting transaction and how it's defined. For the term accounting transaction, I'd like to remind myself that is whether or not there is the definition for accounting transaction under the existing CO. Yes. For a dormant company, would it fall within the definition? Yes. You said that for a shelf company, the definition of shelf company, does that include the purely holding company which only holds on to an asset? Would such a company fall under this definition that it has no accounting transaction?
Action holds on to an asset. I think
Okay.
it's not.
asset 嘅定義包唔包括
Does the definition of asset include a pure shareholding company?
shares? It can be classified as an asset, but holding company in a sense just holding shares in a subsidiary company. Does it fall within the definition of that company doesn't have any accounting transaction? Just that's my question.
I think it will be a matter of whether or not it has had an accounting transaction in the context of the definition of accounting transaction. So if anything has to have been entered into its books or records, then it will not come within the definition. The reason we didn't use dormant company is if you look at the definition of dormant company in the ordinance, there has to have been some activity before it can actually get the status of dormant activity, and it can't be from the date of its incorporation. So we're actually just trying to capture the situation where nothing has happened.
So
and
that
is absolute shelf
Chairman,
companies.
this definition will be a bit wider than dormant company. So company with no accounting transaction is a wider concept than dormant company.
But it doesn't necessarily have had to file a dormant status, but it will be a matter of fact whether or not, because it can't actually get dormant status from the date of incorporation. And our intention is that this exemption only kicks in if it is from the date of incorporation. Anything that might warrant it to need to have some recognition publicly, it has to comply with these regulations. That's our intention.
But to my experience, I think this subsection 4 will be of very, rare application because, in fact, if anybody tries to incorporate a company, it must be for some commercial purposes. Either is holding another subsidiary company, even though it's just a pure holding company, or I cannot foresee how this could benefit our commercial activities because I do not think anyone incorporating company would be leaving the company in a status that it is purely a useless shelf company.
It will be targeted at secretarial companies who incorporate companies for off the shelf to purchase. Some of these secretarial companies, for example, have hundreds and hundreds of companies, so the actual obligation to display is quite onerous for these, and so that is the benefit for this particular exemption.
Thank you, Chairman.
Any questions?
I want to get back to Clause 4 with regard to the registered name and the website issues. Does the websites equate to the applications on iPad, on the iPhones, on even some of the Samsung phones? They do not have websites, but they do have applications. You cannot, I think lately we have a lot of different tablet PCs, and on this tablet PC they do not serve on webs. They do serve on webs through the applications, and you cannot actually find the local website, but they have applications. So do you require these, the applications, and how do you determine, the differentiate the two?
There is in the interpretation section, section 2.3, a little bit of elaboration. A reference to a website includes any part of a website relating to the company which the company has caused or authorised to appear. That gives a little bit of elaboration. I think.
Where's the definitions in the main clause?
Section in Regulation 2, subsection 3.
Regulation 2.
Subsection 3. There's a little bit of elaboration on the website issue that might.
Let me check.
Section 2, interpretation, bracket 3. Can you see it, Mr. Sin? Let me check first.
I suggest you get back to your office and check out, 即係而家啲 iPad、iPhone 嗰啲 apps。
Check the applications being used in iPhones and iPads. It is actually a website, but though it is not obvious. So how are we going to deal with these situations? Well, for Microsoft, even Microsoft, when you use their services, you are using their websites, their applications. They use apps. So what about the apps provided by these companies? Will their company names be required to be displayed? Because the name may appear on the website but not on the apps. Mr. Yu? This is a new requirement. In the past, the requirement only applies to communication documents and transaction instruments. Even they are transmitted through the electronic form or as email, they will be covered. But in the past, there's no requirement on websites. But we note that websites are very now common for companies, so we have added this new requirement. Mr. Sin mentioned apps. Apps are different from websites. It's true that some of the apps might link back to the company's website where the name should be displayed, but apps, if you just look at the definition, then perhaps they should not be kept caught. Now, for apps, perhaps it's used for a mobile phone, then where space is limited, it may not be feasible to require the company name to be included. So it will be more because a website is much bigger and is more flexible, and it may be appropriate to cover websites. But if apps are to be included, there might be practical difficulties that have to be considered. So at the time being, we will not extend the requirement to cover apps. Here it says specifically websites. Apps may not be the same format as a website. It may not even be there may not even be a link to a website. I think you should go back and consider this to whether you should extend it, because you do not amend the regulations very often. Well, in the past, for desktop applications, it's true that people have to click onto a website, but I think it is a rising trend. There's a growing trend for transactions to be conducted through apps, even for banking and buying of tickets for the cinema. Many transactions will be conducted on apps. The reason why you extend that to websites is to let people know the company's name. Since the trend is changing, there is no reason why you should not regulate apps as well. So please check with other jurisdictions to see what they're doing to apps. I think the administration should understand Mr. Sin's thinking. He is more advanced. He has already moved on from websites to apps. Any other questions, please? Mr. Yu? Will you think about Mr. Sin's question? Please think about it and think of possible amendments. Yes, let's go on. So we've completed accounting standards. Companies Directors Report Regulation. Thank you. I think we made a start at the last meeting, and we were already up to Section 3. Commencement, of course, would be the same as other regulations to follow the empowering ordinance, and interpretation, we've done that already. And Section 3, Director's Interest. If there is an arrangement affecting the company or the companies are connected companies. By these I mean the company's subsidiary undertaking or holding company or a subsidiary undertaking of the company's holding company, that is a sister's company. Of these arrangements can allow the director to acquire shares or of the company or interests of the company, then this is to be disclosed in the director's report. In fact, this is a requirement in the existing CO, but as I said in my supplementary paper, we have made references to the UK situation. Currently, the CO covers debentures, arrangements involving debentures, and here we no longer require that to be disclosed in the director's report. So for shares, it's just a replication from the existing CO. Okay, no question, please go on. 4, donations. The principle is just the same as the existing CO. A company has to disclose its donations. If it has subsidiary undertakings, then a report has to be made to cover donations by the company and its subsidiary undertakings. In the existing CO, there is an exemption for donation not more than $1,000, but we have reviewed the requirement. Well, if in a financial year the donation, the total donation is not less than $10,000, then no disclosure is needed. 10 times the previous level. Speaker's off mic. Speaker is not coming through. What's the intention of this requirement? Mr. Yu? Mr. Kwok, can you please repeat your question? Regarding 41B. Donations for charitable or other purposes. What does other purposes mean? What is the intention to include other purposes? Direct Registrar. Thank you. This is from the existing CO. I think the intention is some donations may not be tax deductible, but still the donations have been made for a charitable purpose, although the organization concerned is not eligible for tax deductions. So the intention is to cover such donations. Usually, most of the cases are donations to charitable organizations. All right, Mr. Kwok? Okay, we go on. Section 5, shares issued. This is also from the existing CO. If in any financial year of a company, the company has issued any shares, then a disclosure must be made to cover the reason for making the issue, the classes of shares issued, and also the consideration received by the company. And when a company issues a debenture, is required in the existing CO to make a disclosure. But we now believe that it's just a form of raising capital. So we have not covered debentures here. The issue of shares is a major issue. So all companies are required to make disclosure in relation to such matters, or even for a company that only prepares summary reports, this disclosure is still required. Ms. Jiang, a company, we talk about a listed company or a general limited company, all companies. The Companies Ordinance apply to all companies incorporated in Hong Kong, whether it is listed or not. Should the disclosure be made at board of the general meetings of members? No. In the director's report. No further issues, then go on, please. Section 6 is a relatively new clause. In the past, there were only provisions related to Section 5. That is, the director's report should disclose shares issued by the company. But nowadays, there are equity-linked agreements. Shares would not be issued immediately. However, the directors have entered into an agreement, or rather the company has entered into an agreement to cause a third party to have the right to acquire shares of the company subject to the fulfillment of some conditions. So these may subsequently lead to the issue of shares. So it should be disclosed. Otherwise, if there are many equity-linked agreements without actually shares issued, there will be no disclosure. Now, we have a definition for equity-linked agreement and also the coverage of the disclosure. For instance, the reason for setting the agreement and also conditions for triggering off the issue of shares and also the consideration. So these have been said in this section.
Definition of equity-linked agreement is provided for under subsection 3. Mr. Leung, I have a question regarding section 6. Subsection 1 and 2 of section 6, according to my understanding, applies to a different scenario. First of all, during the agreement has been entered in the financial year and it's been performed, and there is no understanding. In the second situation, at the end of the financial year, the company still has an equity-linked agreement, but it's not yet any performance. So I'd like to confirm whether my understanding is correct. And secondly, if you have a company which during the before the end of the financial year convenes a board meeting, at that board meeting the company said it wants to enter into an equity-linked agreement, and it also has been approved by the board, but the documents have not yet been executed. In this case, does this company need to make a disclosure relating to this equity-linked agreement? Thirdly, at the time of disclosure, does it mean that each and every equity-linked agreement would need to be separately disclosed in the director's report? Director? Thank you. According to my understanding, and looking at this section, if the board has already convened a meeting and passed a resolution before the end of the financial year approving this agreement, but the agreement has not yet been signed, then this agreement will not be covered, because this provision only covers the scenario where the agreement has already been signed. That is, company has already signed the agreement. Regarding disclosure, and whether or not each and every agreement will need to be disclosed, according to this provision, the answer is yes. And for each of the agreement, you need to disclose the contents as required under 6(1) and 2. And in subsection 2, we're talking about on the day the financial year ends, and where such agreements are still valid, then they would need to be disclosed. The purpose of subsection 2 is that for some of the agreements, they have already been executed before the end of the financial year. On the day the financial year ends, all the terms have been executed. Chairman, follow up. Well, in this case, does it mean that anything which has been performed before would need to be disclosed? So in other words, a few years down the road, there will be more and more which need to be disclosed as the company enters more and more agreements. Even if you perform it, you've issued the shares, you would need to continue to disclose. No, Section 6(1) refers to a particular financial year. That is, agreements which have been signed during the financial year. You will not need to disclose agreements signed in previous financial year. You will need to look at the director's report every year. So the scope of disclosure includes the agreement signed during that financial year. On the day the financial year ends, if there are still such agreements pending, then they will still be covered. No, I'm talking about subsection 2 and its coverage. Let's say I've already performed the agreement and the shares have already been issued, but the agreement is still valid. You wouldn't say that after the shares have been issued. Let's say an employee is subscribing to a share option scheme. It's valid for 10 years. Well, the agreement is already valid. And for the next 10 years, in the director's report, you will need to make the disclosure about that scheme. Would that be too onerous as far as disclosure requirement is concerned? My understanding is that under 6(2), if the agreement is still valid, even though it was entered into last year or the year before that, but still the agreement is still valid, you will still need to make disclosure pursuant to 6(2). Is that correct? The answer is yes. Disclosure is required because eventually it involves the issuance of new shares, and this may result in dilution of the share value. The company, I think the membership of the company is different at different times. In a particular financial year, if the equity-linked agreement is still valid, then disclosure would still be necessary, so that members of the company for that year, reading the director's report, will know which agreements are still valid and which may result in the issuance of shares. Chairman, this subsection is rather complicated. Could the administration and the company registrar issue some guidelines or practice notes to companies? Could you do that, Director? Thank you for the suggestion. We certainly can consider doing that. Is this in the existing Companies Ordinance? Well, this is a new provision because of the appearance of this new investment arrangement. We've also covered the such equity-linked agreements. And Jiang. Thank you, Chairman. For such agreements, I think that the arrangement here is to protect the minority shareholders. And this would need to be passed by way of a resolution at a shareholders meeting. Does it require? Is it necessary for it to be passed by resolution? This would need to be approved by the board, and the minority shareholders wouldn't know. And that is why in the financial report and the director's report, disclosures are required. For the typical limited companies, well, this is a regulation regarding disclosure under the director's report, and its minority shareholders only know afterwards. Is that right? The decision rests with the board. Mr. Chung. Could you please wait? Chairman, does this section includes the company raising funds from outsiders, and the organization lending the money to the company has a right to subscribe to the shares of the company in the event that the company failed to repay the amount borrowed? See you. I think share option. You're saying that the company would need to issue shares to pay the debt, or resulting in the existing share value being diluted, issuing shares in lieu of the payment of a debt. It's similar. I have a similar question. For the definition of equity-linked agreement, does it include equity-linked derivatives, forwards, and convertible bonds? I'm referring to 3A(b)(2) and the definition therein. Mr. Chung what Mr. Chung was talking about was equity derivatives, derivative warrants, and convertible bonds. I think the definition should cover those as well. Could you confirm that? Thank you. The definition is rather broad, and if you refer to section 6(3)(2), it said the agreement for the issue of securities that are convertible into or entitled the holder to subscribe for shares in the company. So I think it should cover that. Of course, we will need to look at the specific provisions in each agreement to see whether or not it's covered. I personally think that it covers all those, so long as it is clear, Chairman. Any further questions? If not, then Mr. Yu, please go on. I also like to add further regarding equity agreement. It's similar to the issue of shares. Whether or not the company issues summary reports, a disclosure will still be required. Section 7 is about dividends. It's the same as the existing CO. That is, a direct report must state the amount of dividends paid for that year, for the financial year. Go on. Section 8 is a new provision that if the director of a company disagree with the board and resigns during the financial year or refuses to stand for re-election, if he has submitted the reason why he disagree with the board, the company has an obligation to disclose the reasons for his resignation. The purpose of this is to enhance the transparency of the company's operation. This is a new arrangement. We now propose that this arrangement should only apply to companies which are not granted exemptions, and for companies preparing summary reports, they will not be covered. For large companies where there is a disagreement and a director resigns or refuses to stand for re-election, then the reasons will need to be disclosed. Thank you. I'd like to ask a related question. Under the existing CO, if the auditor resigns, and of course he would submit a letter to the company, is there any requirement under the CO for the company to disclose the reasons for the auditor's resignation? CEO or anyone from the administration? According to the existing CO, there is no statutory requirement for the auditor to disclose the reasons of his resignation. If the auditor chooses to disclose the reason, he is entitled to do that. Under the new COO, he would need to make a submission, and the company would need to deliver that submission to the members of the company for inspection. Follow up. You say it would need to be forwarded to each and every member. Does it mean that you simply display a copy at the company's registered office, or does that letter need to be sent by mail to all its members in the event of the auditors resigning? Under the new CO, that submission will need to be circulated to all members and not just being displayed at the office of the company. It will need to be circulated to all members. Mr. Tong, Chairman, I think the purpose of Section 8 is that if indeed you have a director who gives a reason saying that explaining his disagreement with the board. Now, if that director does that, what incentives are there for him to do this? If the reason is that, say, he believed that he is right, and all the other board members know the reason. But under many circumstances, many directors choose not to give the reason. So my question is this. Under these provisions here, are there any arrangements for the director who wants to state this reason and put it on record? Are there other provisions or exemptions or safeguards or defense, against criminal or civil liabilities, which actually mirror the other provisions regarding liability and so on? Or is it the case that so long if you want to state the reason, fine. If you don't, in the majority of cases, the directors would not state that.
Mr. Yu? Well, according to my understanding, there is really none. Well, if a director decides to resign or choose not to stand for re-election, there can be numerous reasons. We cannot really make it mandatory for him to state the reasons. And whether there should be any incentive, I think we should leave it to the relevant director to decide. And as for to evade liability, well, I don't think giving a reason would make any difference to his liability. Now, if a company has come into a situation where directors have to be held liable, well, it depends on the circumstances of the case, whether it was done with the permission or involvement of the directors. Reasons for disagreement or well, it makes no difference to his liability. Mr. To. 8.1b, disagreement, the word disagreement. You mean disagreement to the company. What about disagreement to other directors or to the chairman? Is that allowed or possible? You want to encourage whistleblowing, right? But first, is the word disagreement the best word to use here? Because here it says a notice of the reasons for disagreement. You're assuming that the resignation is caused by disagreement. There can be reasons, but not really related to disagreement. For instance, in a very extreme case, the company is a thief, or rather, it has committed criminal offenses, I have no disagreement to that. Well, I just want to leave. I have no disagreement that the company should commit criminal offenses. So the company may say that, well, this is not really a disagreement. He's been involved for so long, and he has not stated that he doesn't want to be involved anymore. So do you get my point? Can you, for instance, would it suffice if you say has given a reason, a notice of the reasons, and that's it, or a notice of such reasons? Well, or the company may say that, well, there is no disagreement, and to the company, if there is no disagreement, then the 3 words to the company is not needed. But if you insist on using disagreement, you should perhaps disagreement to the auditors would also be a reason. But of course, if the auditor has given a bad report, then you may say that I have no disagreement to the company, but it's because the company has adopted the auditor's report, which I don't like, then I disagree with the government, to the company. Can you just say has given notice of the reasons to decline to stand for election? Would that be enough? If I just say such reasons, you may say that's too wide. For instance, I am suffering from a certain illness. This has nothing to do with the company. Why should I sacrifice my privacy? I have the feeling that disagreement will narrow down the scope unless you have another definition for disagreement to make the scope very wide. By using the word disagreement, you would narrow down the scope and for disclosure. Well, we should read A and B together. Disagreement is with the board of directors of the company. And B, the director has already given a notice of the reasons for disagreement to the board of directors. Have we widened the scope? In fact, this is a new arrangement. There is no such requirement in the existing CO. There can be various reasons for a director to resign, and if we compel or require the director's report to include such information related to resignation of directors, it may be too onerous. Some directors may resign due to personal reasons. Now, if it is stated that the director has resigned because it disagrees with the company, then it may be a warning note to members. But if the company has a lot of misconduct and are committed criminal offenses, then the director should have reported it to the police. No. The director resigns probably because he doesn't agree to the decision of the board, and as a result he has decided to resign. Can you make it wider? For instance, if I'm suffering from cancer, there is no reason for me to tell you that. I'm not talking about the personal reasons, but I don't want you to use the term disagreement to the company. You should say related to affairs of the company. If his decision to resign or not to stand for re-election is related to company affairs, then it should be disclosed. Because disagreement would narrow this scope too much. I think I get Mr. James To's meaning. Mr. Yu, will you reconsider this? Ms. Ann Chang, is it on a related issue? I've almost forgotten what I wanted to ask. All right, then let's set aside for a moment. No, I've recalled what I wanted to ask, because there just now there's an urgent email which I had to reply at once. I'd like to ask a question related to director's resignation, though may not be directly relevant. See if you want to answer it. We have seen this happening in the past. A director saw that a company had some problems, and for whatever reasons, he resigned. Of course, he sent a letter of resignation to the board of directors and CC'd to the company's registry. However, he did not know the commencement date, the effective date of his resignation, date of when he signed the letter, or upon a receipt by the company's registry, or what? There is a gray area here, because in the interim, he has to know whether he is still a director, because in the interim, there might be some incidents involving the company. Yes, this is not directly related, but remotely related. Okay. Thank you. If a company if a director resigns from a company, then he has to fill in a designated form, and the form should be sent to the registry for filing within 14 days of signing the form. Regarding the effective date of resignation, well, it is an agreement it's something between the director and the company. But you haven't answered my question. Will it be 14 days? Will it be effective 14 days after he has sent the letter, after you have received the letter? Perhaps it can be his personal reasons, or by lobbying, or because of lobbying by the company, he defers his date. So can it be, I don't know whether there is a more certain provision in the CO, because it's uncertain whether he is still a director in the interim. No, the date is not for us to say. In the designated form, or in the prescribed form, there is a date for the company and the director to fill out. We don't know the effective date of resignation. The director is expected to inform us the effective date. But the director has already informed you personally, but the company doesn't want him to resign, so the company has deferred the stamping or sending of that letter to the registry. Ms. Chan. Now you have to understand this. When you appoint a director, you need a meeting of the board of directors. And when the director resigns, he cannot just decide to go. The board will have to handle that matter, has to deal with the resignation. So it really depends on the merits of the case. Unless you talk about a paid executive director, well, many directors are not paid, non-executive. Do they have the responsibilities to inform the board 1 month or 3 months beforehand? Well, if it is 1 month, it's okay. At least there is certainty. Well, all companies have their own rules. When you're appointed into the board, I'm sure the rules will be clearly shown to you. A company should not be so playful to allow you to go as you like at any time. I'm sure there are rules. Well, there are companies without such rules. That's why I want to understand a little bit better. This is for protection of a small director. Registrar? It's not really relevant, not related to this regulation. But there are provisions in the CO and the existing CO also requires a company to report to the company's registry the resignation of a director. Some prescribed form has to be signed and returned to the registry. Mr. Kenneth Chen. Right. I know this is a new requirement, reasons for resignation of a director and disclosure by the company. 818 and B there is the conjunction and in between. Now, if a director has resigned because he disagrees with the company and he has sent in a resignation letter together with his reasons for disagreement, then a disclosure has to be made. However, if in his letter he only mentions his personal reason, then the company doesn't have to make any disclosure, even though in the past there was indeed some disagreement between the two parties. Is my understanding correct? Yes. It depends on the understanding of the matter by the director resigning and whether he chooses to state reason in his letter. Okay. 81B. A director's report for the financial year must contain a summary of the reasons. Summary, the word summary. How should I accurately understand the word summary? Well, it is up to the remaining directors to understand what is the reason of his resignation, because the board may choose to report such things selectively.
Thank you. The specific requirements are not provided here, because in the summary report, I think the reasons reasons for director to resign, I think it could be a letter containing 1,000 words, or it could be very short. So after the director has written several tens of thousands of reasons stating the grounds of a disagreement, I don't think that should be reported verbatim in the director's report. So the company may have difficulties as far as compliance with the rule is concerned. So that's why we're saying here that the summary of the reasons for resignation should be disclosed, and we should only, I think the important point is whether or not the summary report can provide understanding of the reasons for its failure. If the reader of the report cannot understand the reason, then it would not, satisfy the requirement. There could be many reasons for the resignation, but I think we can deal with it in a general manner. It's difficult for us to require that the director should that the reasons should be disclosed word by word. Mr. Chen, so I have some concerns here. Operationally speaking, first you have to provide for what the company needs to do in this scenario. Let's say the minority shareholder may say that, well, this is not a summary report, I want more information. So how can we deal with arguments like this? That is, minority shareholder is not satisfied with what is in the summary report. Could you do something in this regard? Or is it the case that, well, the company only make a very brief summary report, whether you like it or not, it doesn't care? CEO. As far as the shareholders are concerned, there are several things that a shareholder can do. After reading the summary report, and if he still has some questions or doubts, he can certainly make inquiries to the company and require the company to clarify what exactly has happened. And the company has a duty to inform him. And if the member is not satisfied that the director has made omissions in the director's report or has hidden some facts, obviously the shareholder can lodge claims through the court. And the company in this scenario might have breached the rules. If the company has hidden most of the information, then the company would be in breach of this requirement regarding a director's report. And under the new CO, there are penalties for that. Chairman, I'm sorry I was attending another meeting earlier, and I would like to ask a question regarding paper number 8. Yes. Okay, thank you. I'd like to ask a question regarding part 4. The display of the registering company in its communication document, and reference is made to websites. So I'd like to know whether or not there are similar examples in other jurisdictions. Why do you only limit it to websites? Because we're not websites. We're not only talking about websites. A company can launch promote its products through the Facebook or the Twitter. So do you have similar requirements for those as well? Talking about websites, the company may not use its own company website. It could be the website for a particular product or an event. So does it mean for all commercial activities, the display is required? Because many of the websites are not even registered. So how are you going to implement this requirement? And sometimes a company could be, there could be more than one person who can register. For a website, there is actually a website. So in some domains, you would need to first register that. But .hk.com, you don't need to have a company to register the company first before you can register on the internet. Let's say for particularly website .com.hk, do we need to require him to use the name as registered in the domain, or any other company within the group can do it? For .com.hk, a company can only register one domain name, and sometimes the company will use other companies within the group to hold on to the domain name and then that website can actually be used to operate the company's other businesses or to sell its other products. So will this cause any confusion? There are other domain names which doesn't require company registration. Those which do, would you require them to also, display the name rather than? So would there be any confusion? Are you requiring the company itself to register, or the company holding onto the domain name? Because when it involves the websites, this may impact on many companies. A company may not register its full name on the domain name. So how are you going to enforce this going forward? Mr. Mock, I'm sure, is the IT expert. Jim, could you respond to Mr. Mock's question? Thank you, Mr. Mock, for your question and comment. I don't have information regarding the situation in other jurisdictions, but under the new Companies Ordinance, we already have provisions governing websites. Under section Part 18 of the new CO, we allow companies to communicate with its members through the website. So requiring company to make a disclosure on its website, the rationale behind this is that websites are now popularly used, and we want to ensure that the browser would know which company this website is dealing with. The intention is to enable people visiting the website to know if the domain name And the registration regime for domain name, I'm not too familiar with that. But the spirit of the new CO is that the website, we don't know which company that website represents. Let's say it provides a service. So I want to know which company exactly is providing the service and the information on the website that which company does it refer to. But under the new CO, if the service is provided by company B, then the name of company would need to be displayed. But would that be against a requirement regarding registration of domain name? That would be outside the ambit of the Companies Ordinance. Mr. Sin already pointed out that the company will offer its products and services through different websites. So that would depend on the circumstances. If the website represents the company and the person reading the information on the website would need to know that it's information provided by a particular company. In this case, it's already governed by this provision. There are many websites. We believe that in actual operations we have to, the company registrar will only follow up when there are complaints. In the course of follow-up, I think we'll need to look at the actual situation. But I don't think there's major difficulties as far as compliance is concerned, so long as it displays the name of the company, let's say ABC Company Limited, and display it on the website. And I noticed that many companies already are doing that. So going forward, of course, before the implementation of the new company ordinance, we will step up publicity so the companies will know about this requirement. So I don't think compliance will be a major issue. Follow-up, Chairman. If possible, I would like to know whether in other jurisdictions there is a similar requirement and also how it is being enforced. And another problem, or another question rather, is that, say, if several companies jointly organize an event or activity, does it mean that we'll have to state the names of all those companies involved? If the product is being provided by several companies will jointly conduct a marketing campaign. And then the website may not just include one company. Regarding domain name, I accept your explanation, but if possible, at least I think you should talk to the company.hk regarding their modus operandi, because there could be some confusion here. On the one hand, they need to register the name before they can obtain a domain name, and then you say that you require the company who actually operate the business, that's company B. If they display the name of company A, which only hold on to the domain name, you may not accept that. So there you may need to find out what is the requirement about the company. For other companies like .com, .net, or .hk, there is no requirement for a company to have a commercial business registration before they can register a domain name. I'm concerned that this might cause confusion. That is, which company should they put on the website? Could you find out about the policy? Because they require company registration before domain name is allowed. So there may be a misunderstanding here. I think Mr. Mock has put it very clearly. Mr. Yu, could you go back and check further? And give us some written response. Mr. To? So Mr. To is not coming through. I know. We'll let it come back to the section about Director's report. Mr. Mock, you have no further questions, right? Let's come back to the part about Director's report. We're talking about two scenarios here, Chairman. First of all, resignation, and secondly, refusal to stand for re-election on the part of a director. If you have such exceptional circumstances, you say that your the reason resignation would need to be, put on record. But in the event of a company dismissing a director, what happens in that scenario? When company could be a very a company arrangements, you may have a golden handshake for a director to leave. But if the director resigns, this is a rather odd situation. But what about a company dismissing the director, or the director may disagree with the policies of the company? Of course, when the director is being dismissed, I think previously he will not state the reason. If he resigned, he would give the reasons. If the company dismisses the director, since it's not going to be director anymore, he may be willing to make a disclosure. Because if he chooses not to give a reason, he can certainly also do that. Mr. Yu, what about dismissal of directors? Well, the disclosure in the director's report is to enable the members to be informed. Under the new CO, there is a provision providing for a procedure for the dismissal of a director. It has to be done by way of an ordinary resolution before a director could be dismissed. In the process, if that director feels that he's aggrieved and he wishes to make a submission, the company has an obligation to disclose such reasons to its members. So as far as dismissal is concerned, there is a corresponding provision to deal with that under the new CO. Here we're talking about voluntary resignation or refusal to stand for re-election. We would require the disclosure to be made through the director's report. As far as dismissal is concerned, there's a mechanism under the new CO to deal with that. Mr. To, we are vetting a subsidiary legislation. Many things are already provided for in the principal legislation. Mr. Yu, could you remind us which particular section in the principal legislation has already addressed the concerns raised by members so that we can work more expediently?
Well, Chairman, I was following up on this section, and then we told that it's found in the CO. Can you tell us whether the scope of disclosure is just the same or which one is wider? Because here it only requires a summary of the reasons. I don't know whether in that section it is more comprehensive, that is a full disclosure. Registrar? Chairman, in section 462 and 463 of the Principal Ordinance, there is already a requirement. The disclosure is even wider, and then it has to be passed by in a general meeting by ordinary resolution, a general resolution, and then the meeting may also reject that dismissal. And then there's 463. The company is required to circulate the statement to members of the company. So there is already a comprehensive mechanism for dealing with dismissal of directors. Mr. To, one last point, 8B, a summary of the reasons be provided. Now, this is the government, is drafted by the government. So what is your understanding? Let me quote a simple example. Well, director has resigned because of 1, 2, 3, 4 reasons. Of course, to show his dissatisfaction. And Director A has resigned because of he is not satisfied or not happy with the company's policies. Well, I'm afraid Mr. Chan Kam Lam asked a similar question. Mr. Yu, can you please repeat your answer very briefly for the sake of Mr. To? Well, the summary. Well, depending on the facts of the case, the director may have provided a very detailed reason and making it impossible for a comprehensive disclosure to be made at the director's report, and so a summary will be provided. But if the statement is very short, perhaps it's okay for the director's report to just to repeat it. It depends. The summary should make a reasonable reader understand the reasons or the case of resignation. If a member thinks that the summary is not sufficient or even misleading, then it can file a case to the court, and the company might have already breached the requirement to provide a summary of the reasons. But that is the company's responsibility. Instead of a summary of the reasons, why don't you say the director's report must contain the reasons? Well, there can be various scenarios. There are over 1 million companies in Hong Kong. So a director might have written a very, very long resignation to reflect it fully in the report. May make the reader more difficult to understand what's it about. For instance, if the resignation is as long as a book, then the reader won't really know what it is about. So a summary should be provided to inform members of the company, and if need to be, the company can always provide the full resignation. The member can approach the company for that, and it will be more difficult for the company to comply if we don't have the word summary. And why notice? Why given a notice? Now, if I am the resigning director, I will say that pursuant to 8(1)(b, I now give notice and also reasons for resignation. I'm afraid that a director has to mention that he is resigning under Section 8(1)(b) before the company would provide a summary of the reasons. Now, if I just write you a letter, not very formal, will it be regarded as a notice? You should, for instance, say the company should provide a summary of the reasons because it has received a resignation and is aware of the reasons for the resignation, so on and so forth. I'm a bit worried by this term, given notice. No, there is no need for the director to mention this section in order for his resignation to be effective or for this requirement to kick in. The company can only disclose the effect, disclose the case after it is aware of the reasons. So first, the director must have notified the company first before the latter has the responsibility to disclose that. Mr. To, you think that the company may be playing tricks. What about the director himself? No. That's why I'm asking what is the reason or what is the meaning of notice. It is the director's responsibility to give notice for his resignation. Well, he might have given the notice, but the company may claim that he has not received it. Why? I fail to understand. Here it says has given notice, given a notice. Well, if a notice has been given by the director, then the company has to disclose it. And if the company fails to receive the notice, there can be due to various reasons, or the director has sent to a wrong address, And if it is a normal case and the company has entirely ignored the notice, this is not allowed. The company might have already breached this. It is not a defense here. I'm sure there are appropriate means for notice to be given. If we send a letter to Alaska, of course I can't receive it. Well, you talk about the director playing games, playing tricks. So I think the meaning here is if the company has received, instead of the director has given notice. I think it is better if we put in law that the director has given notice, because the company may deny accept receipt. Now, if there is such a big dispute, the case may go to court, and the director can give evidence as to where he has sent the letter. If here it says the company has received, it may not be fair to the director if it is the other way around. Chairman, you are correct. And in the new CO, there are requirements on service of documents. If the resignation is sent to the registered address of the company, then I think it is said in the CO that the notice is deemed to have been received by the government the next day. So, if there is a grave dispute, then I think all evidence will have to be taken together to make a decision. If the director has reasonably given notice, that is already sufficient. Mr. To, would you say has given reasons? Is that enough? Why do you have to include a notice of? Why can't you say just the director of a company has given the reasons for disagreement to the company? Because I'm afraid that the company might argue over the term or the phrase given a reason. Mr. To, if I may discuss with you. No, Chairman, I want the administration to respond. No, I will certainly do that. I just like to exchange with you my views. I think the term a notice makes it more formal and serious. Well, the fact is you want to know the reasons. So long as the reasons are given, it's okay. I'm afraid that the company may argue for a technical point, saying that, well, this is not a notice. So although the reasons are there, this is not a notice. So 81B is not satisfied because the company naturally may not want to disclose the reasons for disagreement. So from a drafting point of view, if it is not necessary, you may as well remove the few words to allay our concerns. Mr. Yu? Let's see if the law of draftsman has any comment on this. Our original intention is very simple. The director has given reasons to the company, and the company has to disclose. Can it be amended here? Perhaps the law draftsman can help. Mr. Porter, are you on the same point? Then I give you the floor first before the DOJ response. Of course, Mr. James To is always very innovative as regards to possible scenarios happening. I think the current version is appropriate to avoid the giving of overall reasons. Now, if I tell you over a cup of coffee, then I am going to resign. I quit. Why? Because I don't like your look. So, if the reasons are not given on a rather formal written notice, then this may not be too appropriate. I think it is better to have a formal notice. And I agree that it is more appropriate to require the director who is resigning to give the notice, because a third party or the media or rumors may provide the reasons for resignation. And will the company be required to disclose such things? to choose the lesser of the two evils, I think it is better for the director to give notice of his resignation and reasons. May I respond briefly? Well, that being the case, then the notice just means in writing. I agree that if the reasons are given orally, it is dangerous. So about reasons in writing, Mr. Chen, or which one from the DFJ? Ms. Poon? We'd like to reflect the policy intention. Usually, resignations or reasons for resignations are given in a more solemn or serious manner to the company, because such reasons have to be included in the director's report. So, I think what Mr. Jie said was very helpful, because the reasons for resignation might just be mentioned casually over a conversation. So by using the two words, and by using the words given a notice, will avoid that from happening. In writing, will not. Mr. To is proposing that in writing to the company, instead of saying given a notice, why don't we say given reasons in writing, Mr. Jie? Also on a related point, there are many places in the CO where a notice is required to be given, and this formula has appeared time and again. It is not necessary to mention in writing every time, because there are established procedures for giving notice to make it legitimate and legal. To say it in writing may actually confuse the matter, may not be helpful at all. All right. Can we do? My is on the director's report. Mr. Ronnie Tong, Chairman, in the CO. For directors' meeting, not notice in writing is always required. So Mr. Jie's point may not apply in all cases, but I think the liability rests with the company and not the director. If the company knows about it, then it has to disclose, make a disclosure. Then we should look at it from the perspective of the company. So. That is from what channel the company has received the reasons for the disagreement. If the other directors, the director doesn't like the look of other directors, well, that is also one reason. Whether there can be an improvement to the drafting, I agree that we should ask the administration to think twice, because the responsibility rests with the company, and we should say under what circumstances the company should bear this responsibility to disclose the fact. Now, if a certain director made a few remarks over coffee, and then the company may not regard it as being serious and did not disclose it, it may not be reasonable to punish the company for that.
Sorry, Mr. Leung is not speaking through the mic. I think they should go back, and it's not just the Companies Ordinance. I think we should also check how this is considered in other jurisdictions. That it is a point regarding the terminologies to be used in the drafting process. So could you go back and follow up on this? We want to ensure there is consistency. You're on the same point? Okay, let's deal with this point first. I agree with the first part raised by Mr. Leung, but not the second part. I think coherence is very important. But in each piece of legislation, the requirement governing notice may not be the same. I think we had a very thorough discussion on this point. Could you, Mr. Yu, go back and follow up on this one? And as suggested by Mr. Tong. Mr. Liu, Ting-kwong. I want to backtrack a little bit and go back to the section regarding director's report. And for this, non-compliance will result in a criminal liability. One of the requirements is the company must follow the requirements in Schedule 5. If I look at Schedule 5, Section 1A, I have a concern here because I use the term fair review. So is it your legislative intent that it should be looked at from a objective standard or subjective standard? What is fair or not fair may vary from person to person. But for the directors, if they have, let's say if I say this is fair and you say it's not, and if I'm wrong, then I'll be held criminally liable. So I'd like to know whether or not this should be determined by an objective or subjective criteria. My second question is in respect of Section 2, which is in Schedule 2, and that is 2A-B Roman 2. And I'm referring to the English version, and it's very clear here. But if I refer to the Chinese version, I'm totally at a loss. But many people in Hong Kong may not be able to read the statutes in English. Mr. Ting-kwong once said that drafting is because we've drafted the provisions in English, and that's why sometimes the Chinese version is not has a problem. So I really don't understand what the Chinese rendition means. So I'd like to suggest that this should be amended as follows. The company complies with the relevant legal regulations and ordinances and resulting in the serious implications on the company. I think that is more consistent with the English version. It's not really a literal translation, but rather interpreting the intent. That's my second point. I fully understand Mr. Liu's point. Can we still, do anything about the schedule to the principal legislation? A separate issue. I'm sorry, the Company Ordinance was already enacted during the last term, so there's nothing to do about it. We can only, scrutinize the subsidiary legislation. Does that mean that there's nothing we do? No. We can ask the administration to amend Schedule 5. Mr. To. Chairman, I'd like to also, I'm afraid that they don't understand my point, so I'd like to go back to paragraph 8.1a. There are two scenarios here. 1A, the director resigning. Secondly, he doesn't stand for re-election. In my opinion, you say because of the disagreement with the board. I don't want it to be disagreement to the company. I want the resignation, for example, is related to the affairs of the company, for example. Something that is related to the affairs of the company. I think that would cover disagreement, definitely, but the scope is broader. And also you would allow enable the members know the reasons why he resigns. To put it more plainly, you just want to know why he resigns. You want to rule out personal reasons. If I suffer from cancer, then it's not disagreement with the company. Unless you say, I suffer from cancer, I believe that I can continue to serve as a director, But the boss said, no, I said I can no longer serve, and the boss said, no, you can still serve as a director, then there is a disagreement, in which case you need to state that. But this is not what I'm talking about. What I'm saying is that the resignation, any reasons for the resignation related to the company should be stated. So my starting point is 8(1)(a). If the government doesn't do it, I will consider myself how this could be broadened. Mr. Yeo, I think we need to consider two aspects here. If we're going to expand the scope here, it will have an impact on the company. In respect of the resignation of any director, the company will have to consider whether or not it should be disclosed in the director's report. The details to be disclosed will be increased, and there is this compliance issue, the burden of compliance. And secondly, if have to disclose the operation of the company causing the resulting resignation, then there might be too much information disclosed that the members may be confused. I think the important thing is that when there's a disagreement among the members of the board, we believe this is a serious matter which the members of the company should be alerted to, so that they can follow up but as far as the operation of the company, let's say a director disagrees with the direction of the company, it says the company is no longer selling its political product, and the director disagreed and he resigns, and in which case this will need to be disclosed. What we're worried about is the disclosure of information which really members need to know. So our original intention is that we should only disclose information which must be disclosed. I don't think using your example, the company that discontinues with a product line, the director disagrees. There is a disagreement here. So when there is a disagreement, I think it should be disclosed. But if it's related to the company's affairs and the director has to resign, then you are saying that many directors may resign, and this will result in confusion. Don't just give us an easy, a speedy answer, because it may not be right. If you really genuinely feel that this might be confusing, that there are 10,000 notices to be disclosed, does that really mean that there are so many directors resigning? I don't want you to have a situation where among 5 directors resigning, for one of them, he resigned not because of disagreement. I think the Bureau fully understand your point, and all of us also understand your point. Mr. Poche. If you have scenarios which happen frequently, and if the number of companies affected are relatively limited, then I will accept Mr. To's point. But when we enact a piece of legislation, if we're talking about 1 or 2 companies where you need to exercise a lot of creativity before you can think of such a scenario, then I think those examples are not really useful, because these provisions apply to all limited companies, and for many limited companies they are rather small in scale, and they may not have a company secretary dealing with all these notices and so on, and this provision provides for a criminal liability here. So only when there is so I think we should only do it if it doesn't cause too much nuisance. Well, Mr. To's suggested scenario is not very practical, and it's not very likely to happen. If we talk about things related to the company, there could be many. Other than product lines, there could be disagreement over personnel matters, change of address, or rental review, and so on. There could be disputes over all those things. and if you require disclosure for all such details, the disclosure system could be flooded. Mr. Toh. I think we already had a very lengthy discussion over this point. I think we need to make this clear. The government will need to go back and think about it. According to Mr. Chair, even for trivial matters, if the board members disagree, then there is a disagreement and you have to disclose. There may not be disagreement, but there are issues which the board or the directors think there is a problem. Then you should enable the members to know. You talk about the system being flooded. I just want to rule out things which do not fall into disagreement for technical reasons. Well, this is a new, bill, and it's not the case that whatever the government presents to us is the best. That's not what I'm saying. That's why we need a discussion. I know, Chairman. I may not be able to come up with the best idea, but we still need to do a discussion. This is something new. Well, you're entitled to express your views. You also have the right to make amendments. Chairman, if a member says what the government proposes is not the best and you always chip in, what do you mean? Am I entitled to reply? It's about the attitude of you being the chairman. If you say that what the government proposes is not the best, you are allowed. I agree. Nothing is the best. I think it always get better. I'd like to know whether or not there have been precedents resulting in government adding this new requirement. Could you also research into other jurisdictions and whether or not they have a similar requirement? CEO. Regarding case laws and precedents overseas, I don't have the information offhand. We've heard members' views. Perhaps we can go back and consider them. I think the important thing is that the legislation will not cause undue burden on the business sector. Perhaps at this point we should pause, or shall we continue? We don't really have time. There's only one more section. Section 9 only reiterates the requirements under the new CO, because under the new CO, we're talking about compensation for directors.
When the company offers indemnity to a director or third party, then under the new CO, a disclosure has to be made. And we've just repeated the relevant provision in Section 470 of the CO, so that the company can refer to this regulation and be made aware of the relevant requirements. And if Section 470 is not complied with, then I will be subject to the penalties under Section 388 of the new CO. All right, Mr. Toh, Chairman, I don't quite get it. So now, if the principal ordinance has already got the penalties exactly or identical to Section 9, then we don't need Section 9 here, because the penalties can be found in that provision. So I'd like to know what has Section 9 added to the relevant provision of the principal ordinance here. Well, 470, Section 470 of the ordinance has already got this requirement, but with no penalty. Oh, got it. All right, so this one will set out the penalties. Okay. Legal advisor. Speaker is off mic. Speaker is off mic. The administration says that Section 9 is a repetition of Section 470 of the ordinance. Yes, the English version is more or less similar. For members' information, the Chinese version is a bit different in wording and expression from Section 470 of the ordinance. So what is the difference in expression? It's hard for us to look at the principal ordinance. For instance, Section 9 of the English version, there is this bracket, whether made by the company or otherwise. And the Chinese reads.
咁喺470條呢，基本上呢，呢一個英文。
Well, this says the two are identical in the English version. But in the Chinese version, Section 470 has the Chinese character C, meaning is. Well, so it's just textual difference. All right, we will go and check to ensure that it is identical to the principal ordinance. Mr. James Toh. Here there is a penalty, whereas in the principal ordinance there is no penalty. I'd like to ask why the penalty has not been put in the principal ordinance. Because there are penalties for breaches in the principal ordinance. Are there reasons for that, or is it because here it is more detailed? The principal ordinance has various requirements for director's report, and mainly in Section 9 or Part 9. But however, in other places, for instance, Section 470 is in Part 10 on indemnity, and that a disclosure has been made in the director's report. I don't see any particular reason for not including the penalty there in Section 470. Our position is, since there are so many requirements, we want to focus all the penalties in Section 388 regarding director's report. So if a director's report has breached the requirements here, please refer to Section 388 for penalties. Well, there is no change in the content, but if we do not mention Section 470, then the penalties under Section 388 will not apply. And it would be difficult for the enforcement of Section 9, and therefore we have decided to do so here. All right. We still have one more regulation to vet, so I think we need another meeting for sure. The 6th of March from 10:45 to 12:45 for Wednesday. Are members available? The Secretariat has reserved this slot for us. I know Mr. Liao will be in Beijing. I saw Mr. Liao shaking his head. I know you won't be available. What about the rest of us? You would also like to attend? Well, please try to accommodate me if possible. We are hard pressed for time. We've extended the scrutiny period to 27th of March, and we have to make a report to the House Committee on the 15th. The deadline for giving notice to amend the subsidiary legislation is the 20th. Can I provide written submissions? Certainly. All right, date of our next meeting, the 6th of March. How about the 7th? Well, if it's not available on the 6th, of course, 7th not before the 17th. He is to attend the NPC in Beijing. I can only accommodate Paul, not Mr. Liu. Doesn't matter. Can we do it later of the day? Or the 7th? The 7th. 10:45 on the 7th. Okay. But please do not just accommodate me. We have to see whether we have enough members to form a quorum. All right, let me check my own schedule first. All right, then date of our next meeting is the 7th of March, Thursday at 10:45. So administration, please be prepared. Please prepare a reply to our queries raised today. Thank you. Meeting adjourned.